Good afternoon, everybody. Thank you so much for joining us. As always, we're waiting for everybody to get signed in, so it's just going to be a couple of minutes here before we get started, but we're so glad you could join us today. It's already July. I'm not really sure how it's already July. JP and Rachel,
I feel you on that one, Tammy. Yeah,
yeah.
every time I turn around, I'm literally just now getting used to writing 2025, and before we know it, yeah, we'll have to move the digit up.
Yeah, exactly. Have you guys? There's some good movies out right now. Have you guys went to see any of them?
Not
I bought
yet, but I
tickets.
do have a list. I have a list, definitely some blockbusters I want to get to. What's on your list, Tammy?
We were talking about going to see the F1 movie.
Oh, yes, that's on our list as well.
Yeah, I actually heard that's really good. Um, Anything else on your list?
I've heard the Superman movie is a good one.
Okay, nice.
So might be, yes. Looks like we have some people coming in here. Yeah, if anyone else has some suggestions, throw
My
those in.
kids are thrilled about the Happy Gilmore movie, but it's coming out on
Uh,
Netflix only. The Happy Gilmore 2, which we're all Adam Sandler fans in our house. Good afternoon, everyone who's saying good afternoon. And Janine says F1 is great. Okay, yeah, that's what I've been hearing. That's awesome. Welcome, welcome, everybody. We're talking movies to see this year and how fast this year has gone, and we're just waiting for everybody to get logged in. I'm just going to give it another few seconds here, and then we're going to get started. Oh, Lisa says Superman was meh. Thumbs
Oh,
down. Oh,
good to know.
bummer. Okay.
Yeah.
Maybe don't spend the money for the theater if you really want to see it. Watch it when it. Yeah. Oh, and then
Oh,
someone else said Superman was great. So there you go. There's.
you never know. And then 28 years later, it's I think a trilogy on that one. We had the 28 days, 28 weeks. So yeah, I've got some sci-fi lovers out there too. That's one I definitely want to look at, check out.
Okay, well, I think we're about 3 minutes in here. So even though I would love to sit here and talk movies and vacations and all this stuff all day, we probably want to talk about some factual denial. So let's go ahead and get started. Good afternoon again. I'm Tammy Welty. I'm the Director of Training and Communications here at Bradford and Barthel. This is my 22nd year at the firm. I love it here, and I'm really glad to be here. JP Torres and Rachel Wilson are excited to talk about factual denials during today's 60-minute webinar. I think we should get into some introductions and meet our speakers. Rachel, would you like to start us off?
Yes, definitely, Tammy. Thank you so much. And thank you, everyone, for being here today, for taking the time out of your schedules to join us. We've got a great presentation prepared for you. As Tammy said, my name is Rachel Wilson. I work out of the San Jose office as an associate attorney. We primarily serve the Bay Area boards such as, well, San Jose, Salinas, San Francisco, Oakland, down to Stockton, pretty much anywhere and everywhere. We are definitely here for you and happy to help. Fun fact about myself, this summer, in addition to movies, I have been working very, very hard on obtaining my donut specialization certificate. Not sure if that really is a true thing, but I would like to believe that. For anyone who knows me, you know that I have an extreme love of donuts. So I'm always looking for good donut recommendations, and I do love doing these presentations because I come away with some of the most amazing donut destinations. So if you have some, please feel free to put those in the Q&A section. And as Tammy mentioned, if you do have questions, put those in as well. We'll try and get to everyone's questions, but if not, we will put our contact information up at the end of the presentation, and we will be happy to get those answered. So with that, I will hand it over to JP Torres.
Hello, everyone. My name is JP Torres. I'm the managing attorney of the San Jose office. Rachel already kindly told you which venues we generally service. I also handle some ADR for some of you here. A fun fact about me is I really, really love coffee, especially coffees. I order beans all throughout the West Coast and sometimes the East Coast too, if it gets here fast enough. So I think that's why Rachel and I get along quite well with the coffee and donuts there. So if anyone would like a recommendation on some beans, I'm always happy to chat coffee. So with that, I think we can get started here on just a basic overview of today's webinar. So we're going to go briefly on burdens, that's burdens of proof, etc., and AOE, COE. And we're here today discussing factual denial. So a key element of that is sources of gathering information to make these determinations, methods to do that, using discovery tools in our toolbox to be able to get that needed information, as well as wrapping it up with potential pros and cons of making either an acceptance or denial, basically how the pros and cons of how you make your final determination on whether to accept or deny. A really big overview, of course, California workers' compensation is part of our state constitution, and if you're a legal nerd like me, it's basically something that came from statute, not something you would have necessarily seen in the old school common law. So that really has no day-to-day relevance for most of us, but it's a fun fact. So the statutory sources for workers' comp, of course, is the labor code and the CCRs. Less so would be WCAB rules or the things you would see in the policy and procedure manual. Those are especially important because some of the judges, especially if they're very particular on procedure, that's one way for them to delay your case, because if you didn't follow, for example, the proper procedures for filing exhibits, or they don't like the way you separated them or whatever. I've seen judges, at least in San Jose, use that as a way to continue the case, say you're not ready for trial, and have the parties then try again before finally allowing you to go forward. So these are things that even though not quite as common, it does still something to keep in mind. The last thing there is local board rules. As you all know, the local boards are not really supposed to have local rules, unlike we have for the Superior Court. But as most of the practitioners here will tell you, each board does have its own different flavor, and 100% there are, if not official local rules, then there are unofficial ones that we still must really follow. So let's move along to burdens of proof. The applicant really does have the initial burden of proof to establish that an injury happened, right? So uh, even though we know that the applicant has that initial burden, it is not a very high burden. It's not a very high burden. So when we're talking about things like factual denials, what you'll see is then uh, we're going to be looking at a lot of things that have to do with, did the injury actually happen? Did it happen on day A or day B? That kind of thing. So that's why that's really kind of the main thrust of today's presentation. Now, AOE COE. Now, for AOE COE to attach, of course, workers' comp in California is a no-fault system. So we're really looking at if the incident, the injury, was arising out of employment, meaning was that injury the proximate cause, was employment, I'm sorry, the proximate cause of the injury. And things we look at is time and place. But of course, in our post-pandemic world, where you're going to see a lot more working remotely or not necessarily at the quote unquote office, then that again is another area where you'll see a lot of factual disputes potentially happening. Now, for all of you claims professionals here today, the claims professional does have a role in all of this. When you first get a claim, as I'm sure you're all aware, you do have a positive duty to investigate that claim. Now, when everybody has their own internal procedures on how to do it, but we want to make sure that you thoroughly investigate that claim within the so-called 90-day rule. But keeping that in mind, though, that in some instances, that 90-day is actually shortened. That you're going to see that in the law enforcement arena. Before it sunsetted, of course, there was the COVID presumptions, those kind of things. So the great majority of the time, it is going to be 90 days, but we just want to be aware that in certain situations, you have a shorter amount of time to act. Now, part of that duty to investigate, of course, you want to talk to the employee and find out what's going on, but I want to make it clear that the employee's failure to supply documentation by itself is not a, that can be your sole basis for making a denial, right? That there's no documentary evidence. You do still have a duty to investigate what's going on. And part of that going on with the rules here is it has to be a reasonable investigation to try and determine what happened. So it has to be an objective investigation. And I need to emphasize that objective portion. Good or bad, we just really need to find out what happened, and that's very important. And going along here in that vein, the claims administrator may not restrict their investigation to the specific benefit claimed, or basically, this is basically just saying we cannot make it a one-sided investigation, and any subsequent information that we discover is as relevant. That would be common times you would see that when you have an ongoing employer level investigation, either in-house or an investigator, or you just find out new information, right? So this talks about the claim administrator's duty to document these steps into the file, and I want to emphasize here again that this documentation in the file is likely going to be discoverable, and applicant attorneys routinely subpoena claim files. So, and actually more so if there's an allegation of bad faith. So we want to make sure that documentation in the file shows a thorough but objective investigation to find out what happened, and especially if there is going to be a decision made to deny that wasn't done in bad faith. Now, here's some, we're going to talk about then investigating these issues. So some of the most important things is, of course, communication with the employer. You as claims professionals generally have these things so much uh, for the timeline of the case. You get this before any of us, right? So communication with the employer is very important. You want to get statements from supervisors, co-workers, any witnesses that can support what happened, because as time goes on, as we know, time goes on, the likelihood that you're going to get an accurate account of what happened, or potential availability of witnesses, is just it's gonna get worse as time goes on. So when you get that case or that claim, immediately to try and locate who was there, what happened, as soon as possible, can be critical, especially if the defense attorney, for us sometimes, we're not assigned, for months, sometimes years after the date of injury. And so, at that point, trying to locate a witness, especially depending on what kind of employment you're looking at, there could be there may be nobody left, right? Depending on turnover. And here they're talking about how that initial employer contact can actually lead you to potential other witnesses, maybe employee witnesses, non-employer witnesses that can help. That's probably not as for the non-employer witnesses. Perhaps like if there's like a car accident or something like that, we all get those. So the more facts you get up front, the easier the leads are to follow. So we do recommend that investigator reports and what have you be done as well. I'm a big proponent of sending an investigator out, especially if you're not having any luck with the employer to help assist in that initial discovery. Send somebody out there. I mean, you never know. Maybe the business isn't even open anymore, or what's going on. So it's good tool to have. Okay. So now we're looking at then basis for denial of the injury. You look at, of course, facts surrounding the injury itself. We see here are the two most common reasons we see that you'll see that these injuries are denied, right? One is that the injury was unrelated to work. Perhaps it was caused by a pre-existing condition, or perhaps the injury happened off-site and away from work. Now, my best lawyerly answer, of course, these two things, while they're the most common, of course, it depends, right? Pre-existing condition, that's great, but we could spend a whole nother topic on how then does that pre-existing condition, was that the cause of the injury, or perhaps did that make the applicant more susceptible to an aggravation, which of course is a new injury in and of itself. Now, the injury happened off-site and away from work, as we mentioned earlier, in the post-pandemic world of remote work, that you're going to have to look at more both geographically and temporally, the facts surrounding when and where the injury happened. Okay. So here we talk about again some of the more truncated timelines. It's in red here because even though it's not as common when you're dealing with law enforcement officers and certain other enumerated first responders per the labor code here. The time frame to act really is reduced, and so you want to make sure that you do that because, as we'll talk about later, subsequent denials can be quite difficult, and especially if you miss that 90-day, or in this case 75-day rule, then the injury is going to be presumed to be accepted. So you want to make sure that you're aware of what type of which category, 90, 75, or other, you're in when making these determinations. Okay. Here we're looking at the 90-day rule. Of course, it's 90 days from when the claim form was filed, right? So this slide here talks about when do we issue that denial. So per 8 CCR 9812, it has to be done no later than 14 days after the determination to deny. So what that means there is that if through your investigation, even before the 90th day, and we always recommend that you make a denial or issue that denial as soon as you know. Don't wait until like the 89th day or something. So as soon as you've made that determination to deny, you must issue that determination within 14 days of that. Must issue that within 14 days. This is good to do anyway, because as we talked about earlier about the claim file being subject to discovery, if you've got notes in there, on like day 28, 29, that you've done your good faith investigation and that this is ready for denial, you don't want to just really sit on it and wait. Okay. And keep in mind that a claim may be denied after the 90th day, but it needs to you need to have a showing that the reason for the denial after the 90th day is based on discovery or information that you could not have obtained or received before or within that initial 90-day period. Some examples of this are, of course, a new fact or a new chain of events. I had a case where the claim was accepted. It was going along for about a year or more when the applicant then filed a personal injury, a civil claim in Superior Court, alleging that the injury was not work-related at all. So, a year going forward, it was accepted, benefits being paid, and then all of a sudden the applicant files this case saying this actually was not work-related. It was fraud. I was coerced by the employer to file this. None of this really happened. So in that situation, then of course we issued that denial subsequent to, but that's going to be somewhat rare, right? So you have to be aware if you're going to do a, a, denial after that 90th day, uh, it would be new information. And additionally, you want to be sure that when you do that, you want to have enough facts to support being able to go to trial right away. Because if you issue a subsequent denial, most AAs, at least in my jurisdiction here, they're going to be ready to go and force an AOE COE trial. So, discuss it with your attorney. Make sure that you have all the information you need to really be trial ready, because most applicant attorneys will want to push that issue if you all of a sudden decide that you need to cut off those benefits. Now here we're talking about the so-called partial denial. Now partial denials aren't really a true denial. So functionally, legally, for partial denials, the claim itself is accepted, but maybe some body parts or some conditions remain in dispute. So really, you're looking at a nature and extent dispute when it comes to partial denials, and you see that especially, well, you can see that statutorily why of compensability dispute, the ability to get a panel using Labor Code 4060 does not apply if any body part is accepted, right? So it has to be a true denial to be able to get a QME using that labor code. So just know the difference between partial and regular denial. Now, other reasons for denial, of course, legal issues are other. So in addition to the factual disputes, we got legal issues of why the claim should be denied. Those will be the subject for a different webinar, but just briefly, your classic ones are post-termination defense or lack of employment, no WCB jurisdiction, intoxication, that kind of thing. Each of these, although intoxication could also be a quasi-factual / medical dispute, but these are kind of legal defenses that come up that could be a reason for denial. And of course, medical evidence, right? Doctors saying that the symptoms or presentation doesn't match, or generally that, when the applicant comes in, maybe those symptoms that the doctor, once they do an evaluation, that's not work related, it could be solely due to what you'll see sometimes, what I've seen sometimes is that they have like diabetes or something like that, then it looks like that the symptoms that they're being complained of is not actually something like a back condition, but more like a diabetes condition, something like that, right? So a medical reason for denying the claim. So just talking about all these reasons why a claim may be denied, we do want to emphasize that how bad faith denials are bad. You could be subject here to some administrative penalties for bad faith denials, including, as outlined here. And of course, on a practical level for claim administration, near the bottom of the slide here, you'll see that, usually when a claim is denied, the applicant will go and try and get benefits through like EDD, for example. So they'll be paying for benefits while the claim is denied. So then if the claim is subsequently accepted, you have to deal with the lien, which I believe we'll talk about more further in detail later. Now, this talks about the increase in indemnity rates. This is not as common. However, in certain situations, especially like in my jurisdiction, this does come into play with people who are either making minimum wage here in Santa Clara County. The minimum wage, there's an ordinance that the minimum wage goes up annually. So whether or not you don't have to do anything, there's no scheduled merit based or anything, that it just goes up. So in those situations, you got to be careful if the person is actually a minimum wage worker. Other situations you'd see with this are if the person is a member of a union, and the union has in their collective bargaining agreement, a schedule of raises for the union members. Again, these are not merit-based raises. It's just negotiated increased rates that are negotiated in the collective bargaining agreement. You want to keep in mind of any of those, and you don't want to be surprised at that. Okay, so this talks about the potential. Again, talks about the potential penalties. Here we're looking at 5814 penalties for bad faith denials. And actually the biggest issue for or for us on the legal side, the one of the more an extra thing to consider when you do the bad faith denial is if applicant attorneys do file for these penalty petitions for bad faith denials. A lot of times they would use that as a method or vehicle also to get additional fees for the time used to litigate the issue. Okay. And I have it here. I just wanted to put a reminder, especially in my jurisdiction here in the Bay Area, the San Francisco Bay Area. Our local AAs here are not shy to file these bad faith denial disputes. I think if you are familiar with especially the practitioners in the San Francisco board, you know that it can be a little bit litigious there. So just be aware and just document the file well. Here, the slide again talks about the potential for liens with EDD, and again, the increase in indemnity rates that we talked about earlier. Again, these are the kind of things, though, that you'll want to have a discussion with the employer ahead of time. These are location-based, like I said, example is Santa Clara County, or if they're unions. Those are the two big ones that I've seen the most of that can be a bit of a trap, is the union contracts and when you have just ordinance-based or legal-based increases. Okay. And I believe I'm at the end of my portion here. Let me see, did we have any?
JP, I was just going to say we've had some really good questions come in.
Yeah,
And
sure.
before we move on to the second half, one in particular to pre-existing conditions, it says, what about a physical injury that occurred at work due to a pre-existing condition? For example, let's say the injured worker had an epileptic seizure at work. They fell and sustained a physical injury due to the fall. Would we have to accept the physical injury but not the non-industrial cause? And this particular person says that they have received mixed advice on this topic. What are your thoughts?
Yes, that is a very good question. And actually, the epilepsy is a classic one where, yes, I absolutely agree that the epilepsy itself, I don't think anybody would argue that the epilepsy is caused by work. However, you will see, again, this depends on the specific facts of your case. But in general, if a person has an epileptic seizure, again, non-industrial epileptic seizure at work, causing them to fall and perhaps strike their head on the table or what have you, then the physical injuries resulting from the seizure could be and would likely be found to be AOE, COE. A lot of times you'll see another kind of example for that is somebody faints at work, right? And, again, the fainting itself could have many different reasons why the person fainted, but the subsequent orthopedic, like let's say they break their leg or something when they fell due to the seizure or the fainting, then yeah, those normally would be compensable. Again, depend on the facts of your case, but for the great majority, it would be.
All right. And one other question before we move on to this is in regard to the 90-day limitation. So this particular adjuster says, I have a claim where the applicant attorneys serve the carrier and not the TPA. We are over 90 days from date of service. However, the claim was reported post-term and in response to a good faith personnel defense. Can we still deny, and do we still have a valid factual dispute? So sort of a two-pronged question there.
I'm not sure. Well, if I understand the question, the first part of the question is they only served the carrier, but not anybody else, was it well, again, it depends on, is it the correct carrier? Was it served? Because in general, when the claim form must be delivered to the employer or their TPA. So a lot of the times you'll see this. I it's rare for me to see that they only serve the carrier by themselves. So I think a little bit more facts will need to be kind of fleshed out of that. But let me just give you a general answer, is my best way to do this. So in general, as soon as that claim form is provided to the applicant, they do need to return it to the employer, and or not and or usually it's the employer, and with a copy to the TPA. But what you'll see sometimes is that they'll only send it back to the employer themselves. So whenever we get a new claim, and I have a copy of the claim form, I like to make sure to coordinate with my adjuster to make sure that, hey, this claim form that you received, was this the only claim form that you have? Was this the one that you sent in the initial claim packet and then it came back? Or what could also happen is on the day of the injury, the worker calls up HR, and HR then gives them a claim form that same day and then returns it that same day. And then we don't realize that there's that claim form, and then another claim form is sent, and then that one is returned usually by applicant attorney with in connection with their application packet. Or there could be yet a third claim form submitted by the applicant attorney when they sign up their client with their application. Now you're looking at potentially three claim forms. So you got to be careful with that, because then which claim form applies? I would argue that the labor code is pretty clear that it's deemed to be filed when delivered either personally or by mail to the employer. So that first claim form in time would count, and sometimes you're already beyond the 90 days at that point, right? So in a factual dispute webinar, that also could be a factual dispute, right? So you want to make sure that you find out if there are any other claim forms floating around there, because that is one of the ones that has happened. We have another story actually where we had a case where the claim form was returned to the employer by applicant attorney via certified mail. They had proof of the return receipt, and then something happened where the person either in HR or something kind of just tucked that away, unbeknownst to anybody. And I was much after the 90th day, like 180 days or something after the fact had happened. Then it came to light that this claim form, and they had proof of the mailing, the return receipt, that little green postcard, that they had sent it back to the employer, and somehow it didn't make it to the TPA. So, you do see these things happening. Now, with regards to the post-term defense, that's a whole separate issue, right? Because if it's filed a CT or whatever. But really, when you're just looking at the claim form portion, you want to look at when that claim form was filed or really returned to the employer and or the TPA. Okay.
No, that's wonderful. And we have lots of other great questions coming in. Hopefully we will have time to address all of these at the end, but let's get started. We'll move on with the next half of our presentation. All right. Okay, hopefully everyone can see the benefits of admitting a claim. As with most things in life, you have your pros and cons, your advantages and disadvantages. And we're going to go through some of the benefits of admitting a claim and the benefits of keeping that claim denied. One of the first benefits is you have your TD benefits versus the buildup of the EDD liens, which inevitably, if you do deny a case, that applicant, it does behoove them. They're going to run out, they're going to apply for EDD. And then I will tell you with so much certainty, as you're about to cross that finish line, you think you've got your CNR in hand and you're going in, you'll have that dreaded EDD lien interest that you have to resolve at the end. So that can be a benefit of admitting it. Also, not only that, one of the biggest benefits is the control. You have medical control through the MPN, you have utilization review, independent medical review governing this treatment. And in addition to that, you have the official medical fee schedule, again, bill review there, independent bill review organizations. So those would be your benefits. However, as I said, there are benefits of denying this claim or of denying a claim. And one of the things we like to say here too is if you are going to accept, make sure you are really ready to accept. Once you ring that bell, it is very hard to unring it. So in some cases, it may make sense. The evidence may be there. We're going to go through some of that today, some of the sources. I know a lot of questions came in about that. When do we factually deny it? So we're going to go through and address these. Also, you're going to be more likely to proceed with a panel QME and go through your med legal disputes on that avenue. And then also, maybe another benefit is if you do want that QME in there, you can actually have the AOE, COE kind of looked at early on. But another big benefit, again, is with respect to EDD, so you don't have those duplication issues. And one of the things we want to really hone in on here too is not only do you have the whether or not you are going to deny this claim, there are also audit penalties that come along when you do deny a claim, maybe not in good faith. If it is in bad faith, you want to make sure that you have your file very well documented. As I said, we're going to go through what makes substantial evidence. In this regard, we are very, very fortunate here at B&B to have our own state audit specialist, Sherry Dozier. She is a phenomenal person that helps link not only the legal aspects, but also the claims adjuster aspects of what really is going on in your case. You may have a very low exposure. You may think, oh, well, all the ducks are in our favor. But if you're in the midst of an audit, potentially it may be better to just go accept it. Or if you have, I know in one particular case, she was extremely helpful. We had TPD exposure. It was minimal, but in regard to the audit, it was simply better just to pay it and move on. Here, we're really looking at when we're documenting this file, do we have evidence? This is different from rumors, speculation, and conjecture. So important, we decided to put it on 2 screens. Again, this is not a knee-jerk reaction. We've had employers say, oh, there's no way, that back injury could have happened here because employees in this field or at our work site only get carpal tunnel syndrome from doing the repetitive work of whatever it is, peeling garlic, putting devices together continually, that could never happen. That's not going to be substantial evidence when it comes to auditing a file, to really looking at it. But as I said, we are going to go through that today. So with that, we will also look at problems with discovery. And issuing a denial of all compensability for a claim limits that discovery and options available to the adjuster in regard mainly so much as in self-procured treatment. This tends to be a bigger issue in Southern California, where it's fairly common to have self-procured treatment on a lien basis. Here in Northern California, there is one common facility that does do that, but it's a little more rare, but just something to be aware of. You could be limiting that discovery option. All right, so very important. We are going to go through our methods to obtain this discovery. And when we look at it, we really have to think about there's informal discovery, there is formal discovery. There are ways and steps to go about that. We also need to take into consideration, is this a represented applicant? If it isn't, we've had cases where you may be sitting there. If we file a DOR, it could come back. You could be on the hook for hourly attorney's fees on that, in addition to 5710 fees or anything of that nature later. So when you're dealing with that, sometimes it actually is in your advantage just to strategize, see if you can sit and wait, have the applicant go about filing something, but definitely you want to be aware of that potential in your discovery method. So really the crux of our presentation today and in factual denials is, what the heck is substantial evidence? What does it mean? I swear, if I ask every single one of you, everyone would probably have a different answer. And that truly is because it is in the eye of the beholder. And what that means for us, it's even in our labor code, it is the trier of fact. As long as it's supported by substantial evidence, the judge has discretion to make these decisions, to determine what is substantial and what is not. It's not based on that speculation and conjecture. It can be based on incorrect legal theories like, oh, well, he's only been here a day. There's no way that could have happened. You really want to be looking at what you have to articulate your points, what connects the dots. We'll go through some sources and ways that you can look at that. But, we've all had cases where this person is on their maybe even, well, definitely in the double digits. I've never seen triple digit claims, but it could happen. And when the judge looks at this, they just have to look at whose evidence is more beautiful. Is it substantiated? Is it thorough? And really, when we're saying this, we're saying discovery is key, but not only that, documentation. The more documentation you can provide, the better. If it's through an audit, whatever it is, if you think it's a small, minimal fact, add it to your claim notes, add it to your attorney notes. So many times this has come back and been relevant 2 years down the road. So again, document, document, document. And then we have to look at the types of substantial evidence. We often have medical evidence, we have factual evidence. When we're looking at substantial medical evidence, we're trying to get the doctor, the QME, the AME, whoever it is opining in your case. If they say it's a certificate or cumulative trauma versus a specific injury, was there a repetitive injury? How we need a medical diagnosis of that. It's so frustrating when you have a doctor that says, yeah, they hurt their left knee, or this had to have happened here. That's not going to be substantial evidence. You need this causal link between the actual injury, the events that happen, the mechanism of injury, and you want that articulated. And sometimes you really have to press for that. As an attorney, we'll get a QME evaluation. Then we get a supplemental report. Then we're taking the cross-examination. Sometimes it may take several attempts to parse out this information, but again, so important. And then again, we have our factual evidence. This is going to come down to, was it a red light? Was it a green light? Did it happen here? Was it impossible? In these cases, you may have the employer saying, that factually can't be possible. That wouldn't have happened. I had a stack or a column, a water heater braced to the wall. Here are pictures of it. That physically could not have happened. It would not have fallen on the applicant. And then sometimes you may even have this cross and mix of medical and factual evidence. We've had cases more so in asbestos or chemical exposure where you may have a medical factual evidence of the medical evidence where a doctor is saying, okay, this cancer, could it be caused by chemical X? And you're getting their medical evidence opinion on that versus the substantial evidence of, well, this person had concurrent employment, are insured. They were exposed to very minimal chemicals. They were basically checking out books, let's say a library situation, versus working in a scientific lab, cleaning out instruments with toxic chemicals. It physically was impossible for them to ever be exposed here. So in those cases, you do have that combination where you're looking at medical and factual evidence. So really, when we're looking at this evidence, the big key thing here for everyone to consider is, what are our sources of evidence? And really in this, we do have limited toolbox items, we have limited sources, but really our biggest one that we're going to talk about today is the actual applicant. This is the injured person, but we're going to go through each one. We have applicant, employer, witnesses and coworkers. These can be vital to your case, medical providers, and then in some instances we have had to use, or it does warrant, an investigator. And then sometimes EDD will come through. You have different information there. But really, when we're looking at these sources and we're compiling all of this information, we're really trying to think, how do we prove that this is a negative? How did this injury, it just did not happen? How are we going to prove that up? So in this particular regard, the sources, like I said, the applicant is probably the key major source. You want to get your hands on that claim form. You want to see exactly what they're saying was hurt, what injured body parts there are. And if an application has been filed, this is also a wealth of information. If possible, if you can get that applicant's statement, initially I would say, within the first day or two, it's going to be the most accurate. By the time, sometimes if we're doing the deposition, which is also really helpful, at that time they may be represented by counsel. Their version of events could have changed. They've talked to family and friends. And I know for even with myself, if you ask me, well, what did you do yesterday? I could probably somewhat accurately tell you. If you ask what I did a week ago, good luck. I mean, I would say, I don't recall, which is what we get sometimes. So this is so vital to really get that statement. You also want to get their version of their job duties and wages. So many times there are discrepancies when we are at the end of a case or even the beginning as to what the occupation code was. And this does impact PD ratings. So when you're looking at it, was it strenuous? What were they doing? And you want to see what that is sometimes before they go to the QME, because this is what they will be telling the examiner. Also, if they've had prior claims, usually this will show up on an ISO report, but it doesn't always. So sometimes if the applicant is forthcoming and they provide that information, it can be very helpful, especially when you're talking about overlapping body parts or apportionment. Again, as much as you can glean from the applicant, the better. So what do you do with all of this evidence? When you're really looking at it, it's almost like you're putting this puzzle together, or you have this kaleidoscope of all of these images and they're just kind of twirling around. But then if you turn it enough and look, they do sort of come out and make a picture. And so one of the things we're looking at is we're talking about these sources, but when we combine all this information, we really want to look and say, was the date of injury consistent? Was the mechanism of injury, consistent with what they're reporting, with what they're saying now, with what they're telling their PTP when they're going for their QME evaluations? You want to make sure that all of that aligns. The other thing too is, how long have they been employed? Sometimes, you'll have a long-term employee, or you may have a person who was injured on their first day of work. And of course, you're going to scrutinize that a little bit more. You're going to look into it and say, was it really a CT? How did this happen? I mean, granted, you can be injured on the first day at work, but you definitely want to balance that and scrutinize it with a keen eye when you're reviewing these facts. And also, were they a good employee? Were they a bad employee? Sometimes if you've got a site claim, if you have other disciplinary issues, if, for instance, they had instances with other employees, disciplinary issues, you want to make sure you have access to all of that and that you're really looking into it. But you do want to remember, you're not basing the denial on that. Even bad employees get hurt too. I mean, I think, I've had employers say, well, this person showed up every day with a smirk on their face and a bad attitude, but that doesn't necessarily equate to fraud or the fact that they didn't get hurt. So you have to take that into consideration. Other aspects you want to look at is if it was physically demanding. And then really a key important issue is their employment. You want to make sure you're looking at what they did before, what they did during, and after employment. This has come up quite a few times, sometimes with concurrent employment. Injured workers simply stumped their toe at our insured, but here they were now a week later, they've got a shattered foot, and that happened at their other employer. So you want to make sure you're aware of all those facts, mainly so for liability reasons. And, perhaps that other employer denied the case. And so now they're like, well, where do I go and what do I do? So really parsing that out. Secondly, the second part of this, because there is so many things you have to look at when you're going over these key facts, is there a gap between the date of injury in between when it was first reported? We've got that post-termination defense. And not only that, sometimes there may be a gap between the date of injury, the date of first medical treatment. What were the reasons? These are all things that you want to parse out. Is there any witness to the injury, prior and subsequent claims, prior and pending surgeries? So many times this comes up where, oh, this person definitely was injured, they need a knee replacement, only to find out, lo and behold, this is, they're 6'1" or something else is going on. So you just want to make sure you're aware of all those facts. Again, from the employer, so important getting that personnel file. Wage statement, sometimes on the attorney's end, we have a hard time, and it's a little easier for the claims adjuster to retain or get this information just because you have more contact. But it's so important, the witnesses, there again, if like with most jobs these days, employees are perishable. They go, they come. It may not even be dependent on the type of work. I mean, you want to make sure that you're getting those witnesses sooner rather than later, because when you're trying to get a witness 5 years later to testify to something, good luck finding them. And not only that, you want to make sure if it is something where it is a seasonal worker or a project-related worker, that you get that statement soon because it may not be available later. Also, you want the 50/20 form. This is an invaluable resource. It comes in throughout the whole course of a claim. When you're going to settle it, it's always great to have if there's any disputes regarding the occupation, earnings, anything of that nature. So we also have other resources we look to, the doctor's first report, and then if we can obtain any information through the medical records, we would take all of that into consideration. And from investigators. I mean, sometimes an investigator is warranted on these, not always, but if so, they can be very good. Their interviews of witnesses are great. If this comes into play later on, you can, as far as evidence, rely on that usually. Especially with respect to the social media investigation, this is something we don't advise you to do. Leave that to the investigator, because if you want to admit this evidence later, it could expose you to cross-examination. But just making sure you have information sub rosa, again, super important. If you have somebody with a stumped toe who now all of a sudden this escalates, they have DR3 with gait derangement, their sub rosa would be extremely vital if this person is out running half marathons on the weekends. So take all of those into consideration. Again, we mentioned EDD, although sometimes, not the most fun thing to deal with. However, can be a wealth of information, especially if you can get a hold of the application, if you can see the form that was filled out by the applicant. Sometimes there's different treaters. Again, a little bit of this is antiquated. If you, want to speak with someone at EDD, sometimes it can be hard to get your own information, but on here we even say you can seek earlier EDD records. I have not had much luck with this, but it never hurts to ask. So we went ahead and included that. All right, sorry about that. Formal discovery. It looks like here, I will just say it's workers' comp. It's supposed to be relaxed. Is it always? No, but we do have procedures. I mean, we subpoena the witness, we get documents, depositions. We also, many times we rely on a medical opinion. And in these cases, if it is a denied or delayed claim, we've got the 4060, Labor Code 4060, in which we can go for a compensability issue. We can statutorily at the appropriate time file for a QME panel. Then we also have Labor Codes 4061 and 4062. 4061 is not as common. This is usually for MMI issues. And quite frankly, we want the applicant to be MMI, so very rarely would we object. And then also 4062, which is everything else from diagnosis, causation, that you would possibly or have a dispute over. So once that QME or AME is assigned, they can evaluate the case and opine on all issues, including AOE and COE. All right, so I did say earlier before, it's workers' comp. Let's all be friends. It's informal. That doesn't always happen. And if it doesn't, there are measures to seek discovery. You can do a petition to compel and things of that nature. However, I will say before you do that, it is always beneficial. And I know, especially in San Jose, the judges are very big on making sure we meet and confer. We try and resolve these issues before we go seek board assistance. I mean, their calendars are overloaded. And typically 9 times out of 10, I will say, you can resolve the issue. You can certainly redact things if they have an issue with medical records going to the QME. But it's definitely, more beneficial than having to haggle it out in court. If that does end up being the case where you're at an impasse, you can, file for that MSC and move for trial on discovery dispute ruling for that issue. All right, and sorry to speed that along. We had so many good questions come in, and we've gone on this journey through the burdens of AOE, sources of gathering information, what to do with that information. Hopefully, we've given you some good tools in your toolbox that you can utilize. If you have any questions, our contact information is on the screen. Please, at any time, feel free to reach out. But with that, I will say, if it's 3 a.m. in the morning, which is when I get my big thoughts and everything else, please just hold off. Anytime other than that, we'll be happy to help you and answer any of your questions. And with that, I will hand it back over to Tammy.
Thank you. And JP says goodbye, everybody. He had a mediation, so he took off to his mediation. He had a busy day today. But thank you, Rachel, and thank you to JP as well. Certificates, as I mentioned, will go out this afternoon. I will include a link to the PowerPoint. I know a lot of you asked about the PowerPoint, so I will ensure you have a link to that. It's always available on our website, on our training page with the event. We always post it. You can register now for our August 19th webinar with Louis Laris on appellate procedures. And we always appreciate you joining us. Thanks so much, and we look forward to seeing you all again next month. Have a great rest of your week, everybody. Take care.